Welcome to Forensic Perspectives, the legal community's online resource for the latest in forensic accounting, business valuation, and financial litigation support. Your host for this podcast is Mark Gottlieb. In addition to being a certified public accountant, Mark has also obtained many professional accreditations in forensic accounting and business valuation. As one of the Tri-State's leading financial experts, Mark is also a frequent lecturer and writer. Without any further ado, please welcome the host of Forensic Perspectives, Mark Gottlieb.
Thank you and welcome to today's program. My guest today is Stephanie Hagan of Donohue, Hagan, Klein, Newsome and O'Donnell in Morristown, New Jersey. Stephanie has been practicing family law exclusively for more than 23 years and is one of the firm's founding members. Her firm specializes exclusively in the practice of matrimonial and family law, making it one of the largest specialty law firms in New Jersey. In fact, 6 members of the firm were currently listed in the Super Lawyers New Jersey edition. As a frequent lecturer and panelist, Ms. Hagan regularly speaks on a variety of family law topics. She is often appointed as a mediator by the courts throughout the state, and she also handles private mediations. Stephanie is a member of the Executive Committee of the Family Law Section of the New Jersey Bar Association and is a member of the Fee Arbitration Committee in Morris County. Stephanie, welcome and thank you for appearing on Forensic Perspectives.
Thank you, Mark, for inviting me today to participate in today's podcast.
Stephanie, in recent years, there's been an increasing number of cases dealing with palimony suits filed in New Jersey. Palimony has long been based on the law of contracts, where an oral promise can be enforced. But a new law came into being during the last days of the Corzine Administration, requiring that in order for a palimony agreement to be enforceable, it must now be in writing and be executed with an independent advice of legal counsel. Stephanie, before we talk about this law that went into effect in January, could you please educate us and tell us a little bit about the concept of palimony and how it came to be?
Sure, Mark. A palimony action has long been recognized in the state of New Jersey as an action brought to enforce an express or implied contract to support between 2 unmarried cohabitants. Essentially, if one of the cohabitants relied upon the other's promise to support them for the rest of their life, that person could seek to enforce the promise by filing a palimony action against the other. The seminal cases in New Jersey date back to 1979. Although the early palimony decisions found that cohabitation was a necessary element in a palimony action, this concept was ultimately eroded and eventually overruled by the New Jersey Supreme Court in 2008, when the court ruled in Devaney v. La Esperanza that cohabitation was no longer a required factor in a palimony action. The court found that a marital-type relationship is essential to any palimony claim. However, cohabitation is no longer essential to a determination of a marital-type relationship because today there are married couples who may be separated by employment, military, or educational opportunities. Essentially, what the court found was that if they were not going to require cohabitation in a marriage, why should they require it in a palimony action? I don't think there is any doubt that the La Esperanza decision was the catalyst for the legislature in passing the new statute, which now requires all promises to support to be made in writing with independent legal advice.
Well, that being said, with the passage of this bill, what do you think the impact will be on what I guess you lawyers call non-dissolution family law issues, where a person had the potential to make the alimony claim based on a promise to support if the relationship had been terminated?
Essentially, Mark, the new statute or law eliminates the ability for anyone to bring a palimony action unless the promise to support they are trying to enforce is made in writing. As a result, many people who have entered into a long-term committed relationship based upon a promise for lifelong support and have relied upon that promise to their detriment may now be in danger of becoming a public charge. Not being able to enforce the promise will cause potential harm and possible inequity to a dependent person.
In 2008, a New Jersey State Supreme Court judge ruled that a couple does not have to live together in order for one partner to sue for the other for alimony. Is this decision affected by the new law? And if so, effective what date?
As I previously indicated, the case you are addressing is Devaney versus La Esperanza, which I believe was the reason for the enactment of the statute. The legislature was truly upset over the fact that the Supreme Court found cohabitation was no longer an essential factor in establishing a palimony action. As a result, they passed the Palimony statute. The statute specifically says it is to take effect immediately. If you read the editor's notes and the legislative intent, it is intended to overrule the Devaney-La Esperanza ruling.
This bill now requires that people first register their intent to provide support by signing an agreement, just like in a civil union. Will this deprive the courts from making any award in the absence of a legal agreement?
The answer is actually yes and no. Certainly, with a written agreement, you can no longer bring a palimony action against someone who has promised to support you for the rest of your life unless it is in writing. However, I believe that attorneys will continue to file actions under other legal arguments, such as unjust enrichment, quantum meruit, and the like. I believe that attorneys will find a way around it, especially when there is a possibility of harm happening to one of the parties, the dependent party, and especially if the dependent party is in jeopardy of becoming a public charge.
Do you think that this new legislation will require unmarried cohabitants to continually update their intent in writing as their relationship expands or continues?
I don't believe so. I think the legislature is very clear. It doesn't require cohabitants to continually update their intent in writing. It simply says that any contract or promise to support made by one party to a non-marital person relationship must be made in writing, either during the relationship or after its termination. It also says that written promises will not be binding unless they are made with independent legal advice for both parties. So I believe essentially once you have this written agreement, the agreement is done. It doesn't have to be updated.
Stephanie, in researching this topic for our conversation today, I noticed there was a case of a woman who was locked out of the house that she shared with a man for several years. And they never had any written agreement, nor did they ever register their relationship as now is required. Under the new law, would this woman still have a palimony claim?
No, she would not. Not unless she had a written agreement executed with the advice of counsel by the parties, either during the relationship or upon its termination. There is some controversy today over when this law takes effect. And as I previously indicated, the statute is clear that it is to take effect immediately. However, legal minds, not uncommon, don't agree on what does immediately mean. Does it apply to relationships that begin from the date January 2010 going forward, or is it meant to apply retroactively to palimony actions that were filed prior to January 1st, 2010? So that's a legal controversy, and we'll see with the upcoming cases that are going to go before the court. In fact, my firm currently has a couple of them where we filed palimony actions on behalf of our clients prior to the January 1st, 2010 date. And our adversaries are now filing summary judgments, these summary judgments to have those cases dismissed in light of the new legislation. Well, it's not crystal clear whether it's meant to be retroactive or prospective.
That's a very interesting point, because for those in your profession who have studied this legislation to apply it in their professional careers, they could take one position with one client and take another position with another client. After all, they're not an expert as the court defines an expert, so their opinions can vary from case to case. What do you think is going to happen?
I'm not sure. I actually have two partners taking opposite positions in their case. I have one partner who represents the person who is the supporting dependent person in the palimony action. I actually have another partner who represents the gentleman who they're seeking support against. So it's interesting listening to both sides. And I'm leaning more towards it being retroactive. Quite frankly, I think it would be too confusing for the courts to try to determine when a relationship started and what the intent. I mean, it's clear to me that the intent of the legislature was to stop palimony actions unless they're in writing. So if they wanted to exclude every relationship that was a potential palimony action that began prior to January 1st, 2010, I believe they would have said that in the legislative intent.
As you're explaining this, that's exactly what I'm thinking. And it should be a very interesting situation.
Right. But because of the unjust enrichment that will occur and because of the fact that you have people, dependent spouses, who could become public charges, I think the courts are going to take great liberties in how they are defining when this legislation really begins.
Let me take advantage of your company right now. Let's talk about a couple of cases that I know are prominent in this area of palimony. One of the cases that many professionals are familiar with is a New Jersey case called Kozlowski versus Kozlowski. That was a 1979 case. Could you give us some background on this case and share with us why is this case something that attorneys who practice in this area should be familiar with?
Well, quite frankly, this was the first palimony reported decision by the New Jersey Supreme Court and in New Jersey, essentially. It was a decision that was rendered in 1979, where the Supreme Court found that an agreement, whether express or implied, between adult parties living together is enforceable to the extent it was not based on a relationship prescribed by law or on a promise to marry. In this case, the dependent party, and although the parties have the same name, it should be noted that there was no relationship between the two of them. It just so happened that they lived together and they had the same last name. The plaintiff, who agreed to live with the defendant and take care of his home and the children, did so based upon his express agreement to provide for her support for the rest of her life. And the court found in this case that it was a binding contract and it was enforceable. So this is the first case in New Jersey that dealt with palimony.
Now, there was another case, Crow versus DeJoy, also a New Jersey case, that an unmarried person in a long-term relationship may seek temporary financial support from a companion. What were the issues in this case?
Well, the main issue in Crow versus DeJoy dealt with whether or not the court had the ability to order temporary alimony or temporary support in a palimony action. And in the Crow versus DeJoy case, which was decided in 1985, approximately 6 years after Kozlowski, it was also a New Jersey Supreme Court case. They held that a palimony action is an enforceable action between two unmarried adults who cohabitate together. However, they also held that to establish a claim of palimony, you are required to establish a marital type relationship and that the parties lived together and held themselves out to be married. However, it should also be noted that the court found that although there are contractual remedies in enforcing the contract between the parties, there could be no award of alimony, either temporary or permanent.